There's a number of things that you can do if somebody dies without a will, one of which is start an heirship proceeding in the state of Texas. In an heirship proceeding, the court determines who we commonly call the heirs of the party who passed away was, or who we commonly call the decedent in the state of Texas. And upon determination of the heirs of the decedent, the court will appoint an administrator and will also authorize the administrator to distribute the property, amongst other things, to the heirs of the decedent. In Texas, heirs are determined by the court by referring to the estates code. And the estate code lays out the heirs of a decedent's estate. And essentially, they're rules of consanguinity or adoption. Consanguinity, by the way, is simply another word for by blood. By adoption or by blood, people who are related to you. Also by marriage. And the Texas Estates Code provides the order in which property of a decedent is to be distributed to the heirs of the estate. Generally, property distributes first to someone's spouse and their children before it goes back up to their parents and then their siblings. Can a non-married partner inherit in the state of Texas? The answer is yes and no. If provided for in a will by the decedent, yes, that non-married partner can absolutely inherit from the party that passed away. But what about if there's no will? Well, that situation is a little different. This is one of the questions that I get asked the most by a probate attorney that concentrates in contested probate matters. One of the hot button issues are my mother or my father had a guy or a man living with them at the time of their death, and they say that they are informally married, or what we commonly call common law married in the state of Texas. The probate of the state involves also having a hearing or a trial on whether or not a marriage existed at the time of the decedent's death to this other person. The answer to this question can get really expensive for parties. So the best thing you can do is to always have a will, or encourage your loved ones to always have a will at the time of their passing to avoid this type of conflict and this type of litigation. Generally speaking, if the heirs aren't getting along and can't agree on how to distribute the decedent's estate, the administrators are going to be the ultimate decision maker. The administrator's tasked with the specific role of acquiring the decedent's property and distributing it to the heirs. Sometimes distribution, however, doesn't mean, hey, you're getting this car. It means I'm liquidating the car and I'm giving you cash. Again, because of the nature of an administration, a lot of things require court approval. So when beneficiaries aren't agreeing on how the property should be divided, the administrator should look to the court, and it will usually involve some type of litigation over the matter to determine whether or not the property should be sold and how the division should be in accordance with the judgment declaring heirship already rendered by the court. If you have any questions about heirship succession, please call the team at Palmer Law Group today.